Thank you. Hello, Lyric Armstrong, your real estate agent and advocate. All right, let's see if we can. I don't know if you can see me better than that. I don't know. Anyway, we are here. We're in Judge Manning's court. This is going to be a different way of looking at real estate. We've been looking at landlord tenancy, eviction, special performance in a real estate transaction, different elements. We also even looked at probate when we talked about Aretha Franklin and what it means to have a will, regardless of which one they think is the will, versus having a will and a trust. So make sure to check those videos out. Very important that you, as a person of any assets, whether it's real estate or jewelry or maybe a vintage car or something to that nature, or vintage furniture, if you actually want those things to go to a specific person or even an entity, you can give it away to an entity. You don't have to give it away to family members. It's up to you, but just make sure you have a trust on top of that, and we go through the reasons. But today we're at Judge Manning's court. Judge Alex Manning is out of Georgia, and I believe it's Fulton County. And it's really interesting watching her. She is a lovely judge. She's very straight to the point, very, no holds bars, no mess. Okay, so we get a lot of great humorous moments from her. This one's not so humorous. There's a so trigger alerts if you have any DV in your life, or maybe even children involved, any type of trauma there. Maybe this is not the video for you. But this is a different way, like I said, of looking at real estate. One of the ways that Judge Manning has stated, this is not how you go about things. So this is a way for us to learn what not to do. We're here, we're learning, right? So in our learning aspect, we're going to do our housekeeping. And that, of course, means that we are like, sharing, and subscribing. So do those clickable things that cost you nothing, and you really don't have to get up, but, sweep the kitchen, like it, share it, subscribe, all that great thing, so that we can help the algorithm for this particular video. Let's get into Judge Manning's court. Gotta love Judge Manning. She is more reserved than I have seen her in times past. So you're not gonna get the full essence of her. So if you haven't watched her before, go ahead and look up her channel. It's a great watch. It's entertaining and educational at the same time. So we're looking at what Looking at Legal Stuff has provided. So thank you to that channel. You can check them out. They have other items in their tickler, but go ahead and support them. Let's make sure we like it on ourselves, and we're going to head and subscribe. We can share later. But as I take care of my housekeeping with Looking at Legal Stuff, make sure you take care of yours while you are here. All right. So here we are. We are in Judge Manning's court. She is in this box right here. And there's all these other boxes of litigants, or, maybe staff. So the ones that we're actually dealing with is Miss Sharika Johnson and Brian Johnson. These are the two litigants. And Bernie Law, Miss Bernie is the attorney for Sharika. And this is a TPO hearing. So TPO means temporary protective order. And so it may be something different in your state, but for here it's TPO. And let's get into it. It's not long. It's not going to be a long expression. So we're not doing the whole hour and a half, nowhere near that. So don't freak out. But we are having our volume turned up. So my volume's turned up. Your volume should be maybe turned down, unplugged, so that you can hear. I want to make sure that we can hear all of the background. So that's why I make sure to keep the volume up. Okay, here we go.
I guess concerns as well as, concerns related to the petition. So
let's pull it back just a little bit.
Progress. So I think
the writing there, this writing, I guess this is the opinion of Legal Stuff. So just know that that's their opinion. That's not necessarily mine. I didn't even read what it was. So I don't necessarily know if I agree or not, but just, be mindful that this is their video originally. So if you want to see the full contents of it and communicate with them on that level, you can by going to their channel.
We weren't really able to make any progress. So I think the court is going to have to hear, at least from Mr. Johnson. He had some procedural, I guess, concerns as well as, concerns related to the petition. So.
Okay. All right. Mr. Johnson, Ms. Johnson, if you both raise your right hands for me, take yourself off mute. All right. You swear affirm testimony you're about to give in this petition for a TPO is the truth, whole truth,
We're
nothing
gonna
but the
have
truth. Ms.
objections
Johnson,
today. All
I do.
objections.
Mr. Johnson.
I affirm.
All right. Is
All
it just the two
objectionable.
of you, or is there any witnesses, Ms. Bernie?
No witnesses, Your Honor.
All right. What about you, Mr. Johnson?
We're allowed to use witnesses in this case?
Do you have any witnesses?
I do.
Where are they?
Right here.
They can't be in the same room with you. Are they going to have firsthand knowledge?
Yes, ma'am.
Okay. Well, we'll hold them send them out of the room. They can't be in there with you.
Better.
And here's a problem that is going to become very evident during this is Mr. Johnson is representing himself. And that becomes problematic, and you'll see why. But this is just a part of it. You can't have witnesses in the same room with you. You can't have witnesses in earshot of you because you're getting ready to testify and express your rendering of the events and factual basis. So they can't hear what you say. In order for them to be impartial. And the whole point is this is a firsthand knowledge, firsthand account by this particular witness. So they cannot be in the same room with you. And quite frankly, they should be on a different device. I've said this before. You should have your device, your witness or your co-defendant or your co-plaintiff should have their device when they're coming onto Zoom. You're upright, stationary, all that other great stuff. But it's very important that you guys are separate from one another. Judge Manning is the one who was able to catch the mom violating her parole or whatever bond. She's violating her bonds because she wasn't supposed to be anywhere near the child, and they happen to be living in the same house. And because of the feedback of devices, they were able to determine that they were there. That was a different case. So this case, we're going to stick with it, but I don't believe most of what Mr. Johnson attests to. However, there are some elements I just wish he had an attorney that can unveil those elements in a better format. And I think he would have found more favor had he had someone to articulate best on his behalf. Okay. I got objections, honey. It's objection central all the way through this case.
All right, Ms. Bernie, you want to waive opening and just go straight into testimony?
Yeah, I'm happy to do that. I think we probably need to take up Mr. Johnson's procedural issue regarding service.
All right, go ahead, Mr. Johnson. I'll hear from you. Go ahead.
Well, my issue was I never was properly notified about any of this or anything going on. I didn't know about the procedure or anything. I came to my home and there was a piece of paper lying on the ground.
Baker.
And I looked at it and saw it had my name.
It's called drop service. You didn't know anything about nothing. They sent you notice. There was a piece of paper on the ground giving you notice about everything. Somehow you made it here to this hearing today, but you didn't know nothing. You didn't know nothing about nothing. Nothing. No, Your Honor, I don't know nothing. I don't even know how I got here today.
I'm on it and a court date. And so I was real confused about that. I immediately contacted my
And the problem is, if you're willing to lie about something that's so easily disprovable, which they will do very shortly in short order, if you're willing to fabricate the truth there, what makes you think your voice and your perspective of what's gone, what the other elements are, what becomes questionable throughout here relative to behavior and accounting of the truth are the facts? What makes you think they're going to believe it to be true? So one thing you never want to be noted as is a liar. You don't want to be a liar. Don't lie in court. Don't lie in real life and outside of court, because the moment someone can't trust one part of your word, when they feel they can't trust you as an honest person, an honorable person, anything else you got to say is like the boy who cries wolf. They're no longer listening. And now there's a real wolf around, but no one's really listening because you have the nerve to come into court and lie about getting service because you knew nothing about the service. You didn't know to come to court today, but yet somehow you're here today, teleported, just you and your psychic came up to the fact that you had to come over here to Judge Manning's court but you didn't get served about it. There was a piece of paper on the ground that had your name on it, but no one served you.
My lawyer, and told her was that.
And he has a lawyer. Where is your lawyer? Do you still have a lawyer? Maybe he doesn't have a lawyer anymore. Maybe that's why the lawyer's not here.
I saw something and didn't know about it or whatever, didn't know what it was about, or
Ridiculous.
Just by happenstance saw something on the ground.
Ridiculous.
And I was like, is this something serious?
Blah, 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 lie.
As my girlfriend,
I want to hear about your girlfriend.
He had his girlfriend.
No, I'm saying she read through the document to me.
He had his girlfriend read it to him. Was this a bedtime story, sir? Your girlfriend had to read you the papers that was on the floor. The grown man in you could not pick up the papers off the floor and read them for yourself to understand for yourself what was going on in the notice of the hearing, or to call your attorney, because you said you called him and said, hey, I got these papers. I don't know what this means. Can you translate? What does this mean? No, you had your girlfriend read it to you. It was bedtime.
You know what I'm saying? I read through it and looked through it or whatever. I never actually looked at the document stuff myself. So she read through it, showed me what's going on, told me the content of it and stuff like that. And
why didn't you read it? Why didn't you read it?
Because I don't want to read anything that I'm not supposed to have or I don't know about.
So you don't want to read anything you're not supposed to have, you don't know about, but you want to put somebody else in that position. You know who says stuff like that? I don't want to touch something I'm not supposed to have. It's like drug dealers. Like, I don't mess with that because, I'm not supposed to have that. I can't just go around opening up packages that don't belong to me. It's at your doorstep. It's at your doorstep, sir. It has your name on it. You can't read that? Can you read? You read enough to tell your attorney. You had your girlfriend read it. And when she told you this is about a case against you and your wife, actually, because they're still married, it's about you and your wife. Don't you take the papers and read it for yourself, get your own understanding?
So
everybody got to interpret for him. She got to read him a bedtime story. The attorney got to tell him, he got to talk to the attorney. And somehow, some way, the attorney is not here today. This is the day for the attorney to come. This is the date of the hearing. So if you really talk to your attorney and say, we have a hearing this day, I'm surprised the attorney is not here.
Because it wasn't placed, anything wasn't given.
Okay, so according to this affidavit, which too bad you should have read it, according to Mr. Braisman, he personally served you.
He did not.
4:45.
He did not. Nobody personally served me anything.
So the process server is willing to, come on now. This is a process server, not a friend of your wife's, not a neighbor of anybody. This is someone who doesn't have any relationship with any persons within this court proceeding. They are called process servers. What do? They serve people. And how do they do that? With a license. And how do they make their money? Serving people and being able to attest to the fact that they serve somebody, be able to testify to that fact that they serve the person. They're not going to jeopardize their livelihood for you. They don't know you. They don't know you. So now this is stupid. You're lying about something and it's stupid because all your credibility is just flying away with every stupid word that comes out your mouth now.
Okay, well, according to him, he served it. It's filed here and there's an affidavit for him that he did.
And that's all the court needs.
So
I'm disputing that 100%.
Oh, well,
okay,
you're here. You're here.
You said, wait a minute.
Found out some
looks
kind
like
of way.
it's a valid affidavit that he served you here.
That's fine. I'm telling you,
you found it on the ground because he said he placed it at your feet.
He did not. That is a lie, Your Honor. And I will testify to that unsworn on the oath that I never got anything.
I mean, you're testifying to it right now. He said it testified it near the hands and feet of you while located at. Looks like there's been proper service.
So that's how you got served.
So.
So service was dropped at your feet. And this is what I mean. They're not gonna let you don't take it and they drop it. You're personally served. They don't need you to have it in their hand because they can attest to and serve and signing an affidavit saying they refused to take it out of my hands, so it fell at their feet. Service is complete. Service is complete. This is a whole waste of time. Whole waste of time.
That's completely untrue, Your Honor.
Okay, well, we're going forward. Anything else?
Yes, ma'am. What I was saying, yeah, that I went through that, and so you want me to discuss the contents of it, or how do you? I don't really understand how to proceed.
That's your only procedural question you had?
Yes, ma'am. I never received it. I just never served that order properly, and I did, so I wasn't aware about the court hearing. And there was something said about a previous court hearing or whatever, where this was.
I don't know about that, but you're here. So how'd you get this Zoom link if you didn't know it?
Yes, ma'am. I saw it's on the front page. I saw the link, saw the thing. Like I said, my girlfriend picked it up and read it to me.
Okay, well, we're going forward with the hearing.
So you refused to read the rest because you wanted to come to court and plead some type of ignorance to knowing that there was a court hearing, but yet you're here. So what have you done to yourself? Shot yourself in both feet, because there is no credibility to be had to anything you get ready to testify to or bring evidence to, because you are misrepresenting the truth to the court. Sir, just why? 5 minutes of nothingness right here.
So now would you like an opportunity to speak with Ms. Burney or no?
No, let's go forward with the hearing.
Okay, go ahead, Ms. Burney. He's all in.
All right.
Love it when we're all in. Let's go.
We're all in. Yeah, we're all in already.
Ms. Johnson, you're married to Brian Johnson, is that correct?
That is correct.
Whoop,
Right.
He said he had a girlfriend. There we go. We're going downhill right now.
And prior to May or June of 2021, how would you describe the status of your
So
marriage?
this is a hoot, man. You gotta catch
Well,
Judge Manning.
very
She's a hoot.
very unstable. We were married in
So-
2009, and in the first few years it was fine. But we had a lot of issues, a lot of control issues. And we just decided to part our ways, and he moved out, and he's been out for 3 years.
Okay, so he moved out 2018 or 19?
About 2018, it's been 3 years. So he moved out into June, July, I believe it was 2018.
Okay. And you all have lived in a bona fide state of separation since 2018?
That is correct.
Okay. And do y'all have any children together?
We have one daughter. She is 6 years old, Blair Johnson.
Okay. And you filed a TPO against Mr. Johnson, is that correct?
That is correct.
Did you have an opportunity to read the petition before it was filed?
I did.
Okay. And are the allegations contained in the petition true?
They are.
Okay.
All right,
Take
we're
a
gonna
minute
get
and
to
go
real
through the
estate soon
petition.
enough. So let me pause this again. Trigger warning, in case you missed the very beginning of today's video. We are in a space where we're getting ready to talk about DV. There's a child involved. There's no DV against the child, so that's not the extent of it. But just if any parts of that is triggering to you, then you might want to click away. This may not be your video. Or you can fast forward all the way to the end where we give you the synopsis for the takeaway, and maybe that will be just enough for you. Okay, so here we go.
You stated in paragraph 4 on June the 6th that he came to the house and he took security cameras down.
That is correct. He does
Okay.
that. When he comes to the house, he takes down the security cameras that I have in place.
Okay. Was your daughter present during that time?
Sometimes she is, sometimes she isn't. At that particular day,
Why do you need the security cameras taken down in the house? If you know who takes down security cameras in a house or in a location, who covers them up or spray paints them or removes them, you know who does that? Perpetrators, burglars, people that are doing something improper and don't want to be seen doing something improper, don't want to be identified. That's when they take the security cameras down. Why would you be doing that, sir?
she was not there.
Okay. All right. And then you also allege in your petition that in May that there was a physical altercation, and that's really what the court wants to hear about.
So if he had an attorney, he would benefit from an attorney at this point objecting. What did I do with my objection? What? Oh, I put it, okay. I don't know why I put it away. We're going to be objecting all day. Oh, you guys cannot see, huh? Well, anyway, this is objection from Emily D. Baker and Gerard Cosmetics relative to Law Nerds Unites. This objection. We're going to be objecting all day, right? But if he was being represented by counsel, counsel would object to Miss Johnson's testimony because at this point, it looks like she's flipping through papers. So what, we want first-hand accounting of your testimony without the assistance of an aide, which would be notes, other papers. We don't want you reading things verbatim. We want to hear it in your own words. So I know that the counselor did say, is this document a true and correct copy? Can we get this submitted in as to the report of what happened? Now, can you tell me about the reporting of what happened? But I didn't hear any permission given for her to read the report and to go through the report.
So tell the court what happened.
So in May, Brian was upset that I was dating someone and that person was doing my yard, doing the landscaping on the home that I still currently live in.
Which is the marital residence, right?
Yes, which is
the one that he moved from back in 2018.
Correct.
Okay, go ahead.
Since 2018.
It's been gone for years. But he come
18. I've been living there, maintaining the home, the residence, bills, everything.
Oh, that's funny. So legal stuff put the dude is smoking in court. And I noticed that too with this guy here, Marvin Polk, whatever. He is not in this matter. It's like I said, everyone on the screen is not necessarily relative to the matter that's right now being on the record, being, called to the judge's record. But I was like, we do not smoke in court. I think Judge Manning, I don't think she missed a beat. I think she realizes he is smoking, but since he's not a part of this particular case, I don't think she wants to confuse the court record by correcting him and telling him not to smoke. So I think that's the reason why it never gets addressed. But it's like, yeah, dude, you're in court. Just because your case was not called and you're sitting in the back of the room does not mean you're not in court. So the things that you would do in court physically are the things that you can do on Zoom. So you're not driving around in court. You're not smoking in court. You're not supposed to be eating. And if you drink something, I believe it's only water that they allow you to have in court. So yeah.
Then when a few weeks before that, I did explain to him, he came to the house. He was upset that somebody was doing the grass, the yard. He said, next time you need to let me know. You need to ask me for permission and tell me, ask me for permission and I give you permission.
So much control.
If someone could do the yard. So 2 weeks fast forward, I told him that the person I was dating was coming and he would be doing the yard. So he was aware and I didn't ask permission, but I did let him know. And so the day came and when he FaceTimed our daughter, he saw my friend's child. And I guess that alerted him that, hey, this guy must have stayed the night in the home. He then texted me that I was out of line.
She almost subscribes to his statements as well. He's going to testify to this as well. Because she says he FaceTimed our daughter and he saw the other gentleman's child and he becomes aware that he slept over hour and she stopped and corrected herself, the home versus our home.
And the next thing I know, he saw my friend's child, and I guess that alerted him that, hey, this guy must have stayed the night in the home. He then texted me that I was out of line, and the next thing I know, he's coming through the garage door. He didn't, no ring the doorbell, just barging through the garage door, and he said, yeah.
Sick of hiring setters that barely book calls for your business? Use AI instead. We use 5 different AI-driven.
To talk to you right now. He, my friend walked outside. I guess Brian didn't notice. Brian came again. I said, where he at? I need to talk to him right now, And so then they proceeded and they went outside. They exchanged words to what I don't, I wasn't out there. I don't know what they said. It's just hearsay. Basically the gist of the conversation is hearsay, and what it was that he told him he could no longer stay in, he couldn't come to the home anymore. This is his home, and that my friend couldn't come anymore. My friend told him, no, I am. So they had no physical altercation. So at that point in time, I guess when he asked my friend, are you comfortable now? You got enough space? You good? You good? And so my friend said, yeah. And I think once he told Brian that he wasn't going anywhere, then Brian started to advance, and my friend took 2 steps back. He retreated. And then he showed Brian that he had a firearm. Like, he lifted his shirt up, or, showed his hip. And then Brian ran in the house and was screaming, cursing. And I guess in the midst of all of his, the excitement, the anger of the situation, he decided to punch holes in my bedroom walls.
Okay, so was it Brian that punched the holes in the wall?
Yes, ma'am.
Okay, and so it sounded like from your testimony, you're saying that he took the first steps toward the other person that was at the house.
That is correct.
Okay. Was there any intervention by anybody? Were the police called?
The police were called. When the police came out, of course, when the police arrived, I was already outside with my friend. Brian came outside and told the police, what are you doing? I called him, talked to me. The police said, I got it, sir. And he proceeded to talk to my friend. Once he talked to him, he decided he wanted to talk to me as well to figure out what the situation was. And then another officer came and started to talk to Brian, and also Brian's girlfriend, who also came with him that day.
Okay.
They both, at that time, the cop pretty much said that, my friend was very much within his rights, because but they both got, Brian had received a simple assault charge, because, Brian felt threatened, but my friend also felt threatened. So he received a simple assault charge. And at that time, when
okay, hold on. Mm-hmm. I'm gonna see if the screen share work. Show you what I marked as Exhibit 1.
So what we need to
You recognize this document? Can you see it? Is it on the screen?
Just your files on the screen. I don't see anything
yet.
Yeah,
we don't see. So it's covered up as to what was shown. So I got it backwards. I thought she'd already entered the report, the incident report, as evidence as an exhibit. She didn't. She had her testify first. And so I definitely think Mr. Johnson is truly losing a lot of potential representation by not having the attorney there, like pertinent representation, because he works on representing himself and it just is not pertinent and all his stuff falls apart. So we're not gonna worry about this. Basically, it's the report that says what she just said. Now?
What is it?
But really, to be honest with you, like, they're objecting to the fact of her looking through papers while she's testifying and reading what it says and testifying to the paperwork is a problem, because the report is typically testified to by the author of the report, and the author of the report would be the officer. So whoever the officer was that drew up the report will say, yes, this is the report I drew up. This is what I was able to collect as evidence. Yes, this is what the complaining witness stated as what transpired. This is what I wrote down. And then they may even attest to some of the demeanor, or what, if they saw markings or something extra that is not in the report. But that goes from the author of the report, who is obviously the officer that is responding to the 911 call. So having her attest to the report is different, but this is a TPO, so it's not, I don't think it's that formalized, because it's a temporary protective order, and it's based upon like maybe a smaller preponderance of the evidence.
It's a police.
But we're just going.
Can you hear me?
It's not pertinent to what we're talking about. Like I said, you can go to the other channel and see the whole thing if you want to. This is not relative to much of what we're talking about today. Basically, he got into an altercation. That's what this was about. The altercation that she spoke to. And this attorney needs help with Zoom, because when you do this, and I need help with Zoom sometimes. We all may need help with it. So it's always good to have a clerk if you can, or a
okay, so to see if she's reconnecting.
Okay.
Help, because she has some hard time.
She's trying to reconnect. Okay, so you identified this.
She fell off, so
this is you asked me if
Any objections? Any objections, sir? Take yourself off mute.
So the attorneys are asking, is there objection to putting this report as evidence? And the judge is asking, he's asking the responding party, Mr. Johnson. And if he had an attorney, I'm sure his attorney would object to it because she's not the author of the report. She's authenticating a report, a document that she did not author. So,
Any objections?
But that's just me.
This is you asked me if do I agree this is the police report?
Do you have any objections to this being admitted in evidence?
The police report, no, ma'am.
Okay, it's admitted.
All right. And for the court's information, the document is certified.
All right, thank you.
All right, Ms. Johnson, I'll also show you.
Okay, that's helpful. That's helpful that it's certified. That means that the author has certified its authenticity. So that jumps over the hurdle of having them come to court to certify it as through testimony. So, okay, so it's already been certified. That's good to know. What are we doing? I don't know what we're doing.
I don't belong.
What does the girlfriend think to see his actions in such anger and control relative to his ex-wife having hit her boyfriend over? It's really not the personal level. That's really not his issue, but whatever. Now, punching holes into the walls devalues the house. I'm sure you know this, right? I hope everybody knows this. So, he's only damaging things that belong to him, which is not a crime. Oddly enough, it's not a crime. For him to damage the house this way is not a crime. It isn't. And, he can repair the damage. I would assume that Ms. Sharika would say, you're devaluing our property, so you need to fix it so that we can sell it and we can have equal share because we are married and we need to dispose of this home so that, half is yours and half is mine.
Is P2?
That is my bedroom and the 3 holes that Brian punched in the wall.
Okay. And are these true and accurate photos of what you just testified to?
Yes.
Okay.
Is our TV suspending from the?
And can you see P3?
Ceiling?
Yes.
Okay, and that's the.
All right, same thing. Okay, great. There it goes on the wall. Got it.
Petition. You also described prior incidents of violence by Mr. Johnson. Can you tell the court what happened?
We had an incident about last June, I believe, where we had a disagreement over a used bike that he said that I knew where the whereabouts were, and I did not. So he told me I was a liar. He said, I will kill you, bitch. Which is normally, when he's upset, that's what he says. He calls me trash. I'm weird. I'll kill you. During that incident.
You see him laughing? You see this right here? This is funny to him. Guess what? Guess what? This judge right here, she sees this right here. She sees this. She sees the laughing. When something is serious and it's important and you want to, confirm your innocence, you're not laughing. Problem is, and I think it looks to me like the judge's eyes are like, kind of like, wow, are you really laughing right now? Well, as far as this attorney, she's not paying attention. And she misses the opportunity to get it put on the record that the respondent, Mr. Johnson, finds this to be funny or a laughing matter as his wife recounts his abuse and his laughter towards his ex.
We were close up on each other's face, and he had his hand in my face, and he spit on me. And when he was so close, he was spitting on me. And when I moved his hand out of my face, and we started tussling on the steps. To protect myself, I did try to grab, like we were on the steps, so I tried to grab anything that was on the wall, and I started to hit him with it so he can get off of me. He pinned me down. I started to kick by anything to get myself from underneath him. He pinned me down to the ground. At that point, his cousin, our mutual friend, came out of the room and said, let her go, like she can't breathe, let her go, Brian, let her go. And she said, I tried to pull him off of me, and he didn't, until she was like, Brian, like my heart, I can't take it, let her go. And then he finally let me go.
Okay, and that's what you described in paragraph 5 of your petition, where you said he threatened to kill you, he pinned you down with his forearm, it made threats to kill you, etc.
Yes, that is correct.
Okay, and were the police called at that time?
For that incident, no, ma'am.
Okay. And have you initiated any contact with Mr. Johnson since you filed this petition?
Since I filed this petition, no.
Okay. And has Mr. Johnson initiated any or made any contact since he was served with the petition?
He just, he had, since he's been served on Sunday, he did come to the residence on Monday to pick up a package from the home.
So this is also an interesting factor. Judge Manning does not allow anyone to come to court smoking, does not allow anyone to come to court drinking, does not allow anyone to come to court in a car, in a moving vehicle. And Madam Sharika is driving, having side conversations with whoever has approached her in her car. And there's been no admonishment of it, because the information that she's giving is very important to the court. And there's I think Judge Manning doesn't want to put any false pretense or have any type of record that will present as if she is, moving things around or, influencing any part of the hearing. It just wants both sides to write it out, both sides to say their part, and then she's going to say her part. I believe her mind was made up before this hearing came about. Honestly, I believe that the pleadings spoke for themselves, and it was just a matter of going through the motion of the hearing so everybody could say what they need to say, and it could be done, because it's very little interaction or intervention by the judge. She does not do much of anything to correct a lot that's going on in her courtroom. And knowing her for the stickler that she is, these things are not getting past her. She just is ready for this to be over because she knows how this is going to end.
And this was after he was served.
That's my opinion.
Okay. And tell the court what you want to tell the court about Mr. Johnson. Do you feel threatened by him in his presence?
I do feel threatened by him because I feel if something doesn't go his way, or he's not in control of me or the situation, then his behavior is very unstable. I'm very fearful. I don't know what he's going to do, when he's going to do it. I don't know what is going to upset him, what's not going to upset him. I can't even walk in my home without the alarm going off, so he can know when I'm home. There is, the trackers on our daughter's phones. Whenever she's with me, he knows exactly where we are at all times. It almost feels like I can't live my life without him knowing every single thing that I'm doing.
Okay. Now you talked about the.
Okay, so I know that sounds controlling, and let me play the devil's advocate, because obviously this is a horrible accounting. So, taking all things on their face, that they are in fact true, it's a horrible accounting for the behavior that this gentleman is distributing against his wife in front of their daughters. It's very bad. But I'm going to play the devil's advocate just to give you kind of like a little perspective. Him having, both of them actually, Madam Sharika and Brian should both have access to the device and its location and be able to locate the device that their daughter is using. That is a good safety measure. Though it may seem ever so controlling, we do have to be concerned with our children's safety. There's a lot going on in the world, and so, we just like I think it's Carla or Carly, who had gone missing for a couple of days. Thankfully, she came back. And whatever the reasons are for her leaving, if she was in fact captured or not, I'm not going to argue one way or the other. I don't have the details to it, but it is one of those instances where we know that there are people out there in this world that do not mean you well. They do in fact mean harm to children. So having a device that can locate the child as long as they're with the device is not a bad thing. It's not. However, if he's using it for a nefarious reason, if he's using it to be controlling against his wife and his child in an inappropriate way, then it's a bad thing. But it could be good. So maybe objection to this. Maybe there is a good time for him to have an attorney to object to improperly using the factor that he's taking safety precautions to care for his child as a means of controlling his wife. Because quite honestly, in their later testimony, you'll take note that he, in fact, has the child more days out of the week than she does. So maybe having a locating device on the child is really what it's meant to do. Keep the child safe in case there is an issue to find the child.
The violence and the threats made against you, has he exhibited any of this behavior towards your daughter?
No.
Okay. So you don't have any concerns that he will harm her? The real concern is towards you?
Right, none at all. Him and Blair loves her father, she loves him.
Okay. And are you asking for the court to enter this temporary protective order?
Yes, I am.
Against him? Okay.
Yes,
And you're not asking for the TPO to apply to your daughter Blair, are you?
No, I'm not.
Okay. What do you want the court to do with respect to Blair? Well, let me start here. Do y'all have any sort of parenting schedule in place already?
There's no schedule in place. It is some days I know when I'm going to keep her because he drops her off. We've been trying to communicate a schedule, but it's off and on. And even if it's my time with her, he'll still pop up to the house and have his time with her as well. And he said he can see his daughter anytime he wants to, and he can come to his house anytime he wants to. So even if it is something that we try to set in place a schedule, he'll pick her up.
So Judge Manning is here for the TPO only. The court is hearing about the TPO only. I'm pulling aspects out that relate to us as real estate professionals, and then those who, are using real estate as a means of control. He, in this instance, is using the marital home, the real estate, as a means of control. So this is what not to do. This is in essence what not to do when you have real estate and you're married and you guys don't get along, you don't get a divorce. Don't use the marital home as controlling your spouse. But Madam Johnson has ascribed to a great deal of the language that he will later use, and it could be that he said it so much she believes it. I don't know, but this is her testimony. And when it comes down to their divorce, I'm sure the documentation will back it up as well, but also she will kind of lose her footing in regards to fighting for this marital home. She's not going to be able to do that as a means of separation or as a means of her having it in her totality. He wants it. He has an interest in it and he wants it. Secondly, she identifies it as our home, our marital home, his house. She knows that the identity and possession of the home does belong to both of them at the very least.
And he'll spend time with her, even if it's my day or my time.
Okay. So basically he just does what he wants to do.
Yes.
Okay. And so are you asking the court to enter?
No, basically, objection, counselor. Basically, she lets him do whatever he wants to do.
Basically. A sort of a temporary.
And why I say this is because he has a key to the house. She ain't changed no locks. She has not changed any locks.
Temporary schedule.
Yes, I definitely want schedule. There needs to be boundaries set in place. We need to respect each other's space, each other's time. Our child needs consistency. We need consistency, and that's what I would like.
Okay, and what schedule are you asking for the judge to put in place?
If we can have alternating weekends, would be fine. A Thursday to Sunday, and then Sunday to Thursday is what I would like to be in place.
Okay.
And for us to have a mutual a location where we don't have to see each other, party that can intervene and keep clear a public space, so that we don't have to be around each other.
Okay, well, the TPO is issued. You're not going to be allowed to have contact anyway. So what you're saying is you want designees to be able to do the exchange with Blair.
Yes.
Okay. And in your petition, you also asked for temporary child support. Has he been providing any child support at all for Blair right now?
He has not.
Okay. Tell the court how much. What is your current income? How much money do you make?
Currently, I make $30,000 a year.
Okay. What's your hourly rate? Is it?
$13.50, I believe.
Okay.
all of this body language can be disturbing. And it depends on which judge you're in front of, they'll call it out, or they'll internalize it and it will help them to make a determination. And you may say, well, he's just stretching. Is he just stretching, or does he look like he's gearing up for something? I don't know. Depends on how you look at it. There was something there. What was it? There's her pay stubs. You don't need that. Doesn't matter. She makes money. That's all that matters.
Mr. Johnson, you have any questions?
The questions, man?
Right. Any questions for her?
For Sharika, or?
Yes.
Okay.
Get an attorney, people. Get an attorney. I know it sounds so cliche, but have the professionals do the professional things. Have the real estate agents help you sell and buy acquired real estate. You know, for sell by owners, they think that they're saving themselves a commission when they end up losing on the actual sales price in the first place. So you're not really saving much of anything. You're actually just kind of equaling it out. And you may open yourself up to other problems, because if you don't do the sale properly with the proper disclosures and questionnaires and different documents that go into a transaction, if something happens down the line, you could be sued. Right? So let professionals be professional. Get an attorney, because obviously the judge is asking, do you have questions for the witness? The witness is your wife, Sharika. This is not hard rocket science, but since legal is not your thing, it's not where you are, you're not the attorney, then you should get an attorney to represent you. And every attorney knows this. If you're being sued as an attorney, you get another attorney to represent you. You don't represent yourself.
Let me think about it for a second. I'm not very familiar with the court process.
That's
so I'm trying
attorneys,
to learn
professionals.
as I go.
Yeah, you don't know what you're doing. We know.
I have a couple of
we found that out earlier.
Trial where I can dispute what she says, or where I do that.
Right now, you have questions. So you can ask her a question.
I don't have anything to answer.
All right. Anything else, Ms. Bernie?
That is so stupid. That is so. Okay, I'm sorry. I take it back. I'm sorry. That was so harsh. I shouldn't have said that. But that was very ill-advised, and it shows me that you did not get advisement, or the advisement you got, you ignored, because it's ill-advised to allow the woman to get up there and insert all of that evidence. She talked about pre-existence of violence. She talked about you were violent towards her friend, that you're controlling the house, that you're using a device to keep tabs on her and your daughter, and you don't have any questions about any parts of that. So what are you doing? You agree with everything she has to say, or are you saying that it's mute to even ask her? You need an attorney. He should have had an attorney. It's ridiculous. He should have had one.
Sorry, nothing else, Your Honor.
All right, go ahead, Mr. Johnson. I'll hear from you.
And this is here we go. This is where we go.
So
getting somewhere.
She covered a lot of ground and a lot of different things. If the court could, as I take my time trying to remember everything that was said and all the allegations, I want to kind of run them down one by one. First off,
that's why instead of laughing and texting people on your cell phone and having your girlfriend come back into the room and throwing her looks in the middle of the corner, you get this wonderful thing. It's so wonderful. It was an invention some time ago. It's, and it's a beautiful invention that I swear I can't live without. I have to have it. It's so important. It's called paper and pen. Okay, paper and pen. And you write down. Oh wait, she said there was a prior violent incident. These are what she said. Okay, we gotta talk about that. She said that there is a device on my daughter's phone, Blair's phone, and let's talk about that. So don't come with excuses that you can't remember what's going on, because it just happened. It just happened. It's just she just said. It was just said, not last week, not 3 years ago, but she just said these things. You didn't object to any part of it. You didn't question any part of it. You didn't ask her anything. And now you're just going to talk in response to her? That's, no.
Majorly the problem with me being violent, I want to address that directly. I've never in my life touched her. I've never in my life put my hand on her. I didn't threaten her. I'll speak specifically to the incident that she directly responded to about there being a violent situation. I came in my home and just asked her where was an exercise bike. It was during the pandemic. And so I was trying to stay in shape at home or whatever because the gyms were closed. So I had we had an exercise bike, and I asked her where's the exercise bike, because it was in the garage the last time I placed it. And then she said she didn't know where it was or whatever. And I was like, but it was here, like you had access to it or whatever. It was here, so where did it go? And she's like, I don't know. It was a long time ago. So I just asked her about the thing, and she started yelling at me. And she was all the way at the top of the stairs. I was at the bottom of the stairs. There may be 15, maybe 12, 13 stairs or whatever in the home, going from the first level to the second level.
When a person gives you all these details about how many stairs are in the home, don't nobody care about how many stairs are in the, what you trying to say? You threw her down 13 stairs? Is that what you're going to tell us? Shut up. This sounds like a lie. It sounds like a lie. Well, okay, but let's just keep going to the important parts.
Came down all those stairs, and I went up. She came down.
Like, I'm sorry. This triggers me because it's just stupid. It really is stupid behavior. Whether I cannot attest to if there was any particular violence one way or the other, but I can say the presentation of what violence has occurred is very professionally laid out by Miss Sharika, I believe. Yeah, Sharika or Sharik. I don't know, whatever her name is. And he comes back with tomfoolery and blah, 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 blah. That doesn't matter. 50 to 60% of the things that he talks about that are not pertinent to what's going before the court, not pertinent to what was being said, not pertinent to a particular defense. And all it does is compound the fact that he doesn't know what he's doing. And that's what I say when I'm saying stupid. I'm going to subscribe to both of these individuals are highly intelligent and phenomenally made by God himself, as they are individuals of Christ. I'm going to make that subscription. Nevertheless, the activities of today's hearing does not reflect that.
8 of those stairs, I went up 3 or 4. We met on a plateau in the middle. And I was like, stop yelling and screaming at me. You can't yell and scream at me. That's unnecessary.
This is not how you tell the court what happened. The court don't want to hear the blow, blow, blow. This is not TMZ. This is Judge Manning's court.
And as she began to continue to scream, what you gonna do about it? What you gonna do? I ain't scared of you. Like being very, very confrontational. I'm not in any way, shape, form, or fashion trying to have any type of physical altercation or anything with her. She kept screaming in my face, yelling in my face. I told her, stop yelling at me and get out of my face. She proceeded to grab a picture off the wall, hit me in the head and face with the picture, and cuts on my body. Then she started punching and screaming. I'm trying to grab her arm and restrain her from attacking me. She continued to hit me, punch me, kick me. As she did so, I restrained her arm by her wrist and stopped her from hitting me. Then she started kicking me. As she kicking me, I grabbed her legs and pinned her and got on top of her to stop her legs from kicking me.
Everybody in the court, from Jill Allison, is like, what? Michael Brown is like, let me just keep my face straight. I can't say nothing. Oh, I haven't been looking at Mr. Landry back there. I don't know what he's doing. But the Appointe sisters, they seem to be like just trying to hold it in because they probably experienced some mess from somebody. Marvin, he is back there smoking like he watching the TV because this right here is comical to him. He like, what is going on? This is ridiculous. Keisha Brown, bless her heart, she's not a believer. You better be glad these people are not jurors, I mean to say. This is not a jury. Because if this was your jury, these folks do not believe you because you are speaking nonsense. Glenn is over there going like, what up? For real, man? Come on, man. For real. That's all on his face. I can't see Brian Coleman's face. He's too far away from the camera, so I don't know. And we know Sharika over there saying, that is not what happened. So, but the person you have to convince is Judge Manning, and she's not even looking at you. She has turned her face away because she made up her mind already based on the pleadings. Because the evidence speaks for itself, so overwhelmingly so that what you have to say becomes mute because you don't know what to say or how to say it. And all you keep doing is showing how much you're lying.
And restrain her arms from hitting me. The third party who was in the home who will not in any way, shape, form, or fashion, if we against subpoenas, for hitting me, grabbed her legs and pinned her and got on top of her to stop her.
Yes. I didn't even hear that part because I was like going to sleep. I'm like, this is a good little story. Oh, bedtime. It's almost time for bed because I was not even paying attention to the fact that he slipped and said, pin her down, but he slipped on it. And thanks to legal stuff, they caught it and they told us, let's go back and hear him tell on himself. He lied in the beginning that I never put my hands on her. I pinned her down. I grabbed her legs.
She did so. I restrained her arms by her wrist and stopped her from pinning me. Then she started kicking me. As she kicked me, I stopped, grabbed her legs and pinned her and got on top of her to stop her legs from kicking me and restrain her arms from hitting me.
And her got on top of her to stop her legs from pinning me. So, gosh, I forget the footballer in Georgia. He had a murder trial. He just thankfully was acquitted because he was defending himself. But they were trying to take exception. I don't know if that was Florida. Maybe it was Florida. They were trying to take exception for him having an AR-15 versus a handgun because he had a handgun and an AR-15. And why would you pull out the AR-15 and not the handgun? It's like, I'm gonna defend myself with what I got. That which works, right? So he ends up winning that trial. Thank the Lord for that, because the police and the prosecutor was not able to see past their noses. They kept cutting off their nose despite their face. But there was a point in that moment where his girlfriend, or he never would call her girlfriend, he just said his friend. But it was a point in the moment where the young lady kept hitting him, literally hitting him, socking him in his head over and over and over again. And he not once touched her. He told her to stop. He walked away from her. And this was on video camera. This man says, I never touched her, I've never put my hands on her. But then he wants to tell us that she was so physical against him that he had to restrain her by pinning her down, just like she said he did. So
my third party who's in the home, who will not in any way, shape, form, or fashion, if we can subpoena her as a witness, validate any of her claims. The only person in the home who saw what was going on can testify, and I'm 100% for that. That third person say what they saw, or whatever. But she did not have to tell me to do anything.
Is that your witness? Is that your witness? Is that your witness that you have in the other room? Because I thought that was your girlfriend. But since you don't have an attorney, guess what happens? None of his witnesses come up because he doesn't have an attorney to say, Your Honor, we would like to present our case, and a part of our case is some third-party witness, so-and-so. No.
She came and she was like, I talked to her the whole time. I was like, I got her. I'm just stopping her from hitting me. I'm restraining her from hitting me. I got her. I'm not hurting her. I'm not going to hurt her. I'm sitting on her legs and holding her arms because she's punching and kicking me. And I'm telling her, stop it, because I'm not about to get in any type of violent situation with a woman of any kind, because that's not my character. She then, as I was holding her arm, she bit.
Now we're talking about character. All this explanation. Like I tell you, all that 13 stairs, my character and all of that in the middle of what we want to know as facts lets us know that you're just fluffing it. And it doesn't sound credible.
Plug out of my stomach. I have pictures of that. She put a plug out of my stomach, and I'm telling my cousin, like, man, me and my cousin have a dialogue the whole time. I'm like, she just put a plug out of my stomach. And then so I was like, Shay, get her and remove her. I do my best to.
I didn't know what a plug in the stomach was until later, because I watched this to kind of decipher if it would be of any value to us, because I wanted to give us some more courtroom activity that's just not Judge Middleton only, even though he has a much more clearer docket relative to our concerns in real estate. And I don't know people with plugs in their stomach, and I didn't understand that until later. They gave me that. But just remember this. Remember this plug in his stomach. She bit the plug out his stomach.
Avoid her. I don't like being around her in the same vicinity, in the same I don't like her in my personal space. I avoid her at all times because she has reactions and statements to things that I don't want any part of, because I know how this can look for me. I know how this can look when a woman cries violence and stuff like that. I haven't done anything to her, so I make sure to keep myself out of those situations. But she initiates and engages me consistently. That's not the first time she hits me. She also assaulted me prior to that when I came to the house about another issue, and she hit me. And so she assaulted me at least 2 or 3 times. I don't file police reports about anything because that's not what I do. So I don't have it's not a police record about them. But she has definitely attacked me on multiple occasions as the aggressor or whatever, and I never do anything but restrain her. Ma'am, I'm 6'2", 280 pounds. I'm a very large man. I do not have any type of type of useful strength of any kind to do anything to that woman. So
that made sense to somebody, because I'm confused. You're 6'2", 280 pounds, a very large man, but you don't have no strength to harm this woman. What are you talking about? That's an oxymoron in and of itself. Sounds like you sitting on her is gonna give her a whole lot of harm, because you 6'2" and 280 pounds.
It's a blatant lie, and like I said, the third party who she claims would as a witness the thing told me verbatim that
Right.
she does not agree with her account on the statement and would say so. The home, let's go back to the beginning like they did. The home was never vacated. Me and Ms. Johnson agreed in 2017 that our marriage was not working. It was not going anywhere. It was not processing, and we should mutually separate. In doing so, we cannot continue to cohabitate in the same space. So what I decided was I will go and get a secondary residence in addition to my home. In addition to the shared property, I will get a secondary apartment so we don't have to be up under each other and can live our own separate lives and do things the way we want it. I want my own space to be able to do what I want to do, not a space that's shared with her. Because I can't bring, if I want an entertaining company, I can't do that in a home that we both mutually own together. That's disrespectful if I bring a female or whatever in that home or whatever.
Now we're talking about, okay.
And try and have a relationship area location to be able to run as I see fit. And so in doing so, I never,
you don't know what respect is.
Step or phase of this said, this is your home, I'm leaving it, I'm whatever. No, I still continue to come over daily or about every other day. I continue to sleep there. I continue to come take naps in the middle of the day. I will come pick up my child. I come and build, we come do posters, we do projects together. I'm in and out of the house. I still maintain the property. I still cut the grass. I still service the yard man. I still have all my stuff stored there. I still have music equipment. I have clothes. I have gardening equipment. My grandparents are hanging on the wall. I still have my pictures of myself and my mother on the wall. I still fully have 100% access and use of that home. I still come over for.
Now he ain't lying. He ain't lying. This part right here is like, he ain't lying. We're gonna get there, y'all. We almost there.
For dinners, for different things like that at times. Thanksgiving dinner, 2020, like that, I carved the turkey. We still jointly function at home. It has never been I totally removed myself from that situation and vacated it. I've never vacated the home. I still paid the mortgage on the home from 2018 until 2019 when me and Ms. Johnson mutually agreed.
So I really just want you to respond to the violence. You guys ain't got a divorce and y'all need one. I mean, I don't care about you paying the bill.
Okay, I'm gonna let the rest go. It's interesting. It's something to look at. It's only about, I want to say 45 minutes. So you can go ahead and go to let me make sure I get the whole name for our provider of our video. Looking at legal stuff. So go to Looking at Legal Stuff on YouTube, support their channel, and check out that particular video, Judge Manning's courtroom. Because the rest of it, bottom line is he loses. And mostly he loses because he doesn't have the wherewithal to really present the case that he has. So he's doing it in a manner that really, I don't know, like the punching the holes in the wall. He says, I did that because I was trapped in a room because her gentleman friend had a weapon, and so I was protecting my girlfriend and my daughter. I think that's who he says he was protecting, because the girlfriend came over too. I mean, how brazen is that? The girlfriend came over too. And the whole control issue, he has control issues, but I don't think he's controlling who Sharik is dating as much as or as much as Looking at Legal Stuff was presenting. I believe that he's controlling of the house, and the house, he counts it as the marital home. This is where the mother of his child lives and where his child lives. And he lives. He gets his mail there. He is there every day. He takes his showers. He gets his, and then he leaves and goes to his boom boom room which is his side apartment that he pays on that. He paid on both. Now the judge kind of cuts him off because he says 2019 we had an agreement. I don't know what the new agreement is. But this is not the way to evict anyone. This is not the way to claim rights to a property. This is what we're here to learn, because there's all this other stuff going on. But the reality is the court was listening to the TPO, the temporary protection order request. So that hearing is that he loses. And, you know, like I said, if he had an attorney, he might have still lost, but he definitely would have had more articulable understanding as to what his defense inside was, versus him coming in like a bullhorn, you know, just knocking things down, talking about things and like, what? You're not making any sense. For the case that's before the court. That's the important thing, the case before the court. But I'm gonna pull it out the court because we have something else to talk about. So I want to talk about dealing with some of the aspects of ownership. Having mail sent to your home or to a home helps to establish residency. Okay, so if you have someone sending mail to your house and they don't necessarily live there, they don't have rights to live there, then that's something you want to rectify, because they can use that to prove that they have residency there. And if they're not paying you rent, you know, what do you want them to be a tenant for? Right? So they're not paying rent, they're not contributing. So that's one aspect of the real estate that's important to note. The other aspect is he stated that he was paying the mortgage up into 2019. We're in 2023 right now. I don't know when this case was heard, because it sounds like the case was heard in 2021, 22. I think that's the time frame. But that being said, if he's no longer paying the mortgage and she is the only one paying the mortgage and she's the only one paying the taxes for 5 years, then she would have a defense against his supposed ownership and be able to say that she has acquired the property through possession, adverse possession, in the state of California. Okay, this is Georgia. I don't know what Georgia has for adverse possession. They may have it, they may not. But in the state of California, if you have some activity that presents like you are the owner of the property and the other person does not, and you've done this activity for 5 years straight, then you can file ownership under adverse possession. So some of the things, the factors that would cause her issue would be the fact that he still gets the mail there, he's there daily or every other day when he feels like coming home and taking showers, his pictures are there, his items are there. So in his defense, it is ridiculous that she would have her man come over and his pictures are on the wall. Now, if you're saying the picture is him and his daughter, then maybe the other man is like, well, that's the daughter's daddy, so you know she gonna want to have pictures of her daddy on the wall. But if you, Madam Sharika, complaining victim, if you say, I don't want anything to do with him, we're separated, we have nothing in common, then why do you have his pictures all over the place? You know, other than maybe she feels like he's extra controlling. But I promise you, I said it earlier, he is controlling especially of that house, based upon the fact that she lets it happen. She's not like, this is the first, well, I don't know if this is the first time, but this sounds like the first time that she's made a step to really get him to understand he should not be coming over the house without announcing himself, without permission, that he does not control aspects of the house. And unfortunately, Judge Manning is not there for that. That's what family court is going to have to cipher out and figure out relative to the ownership and what should be done with the home. But the thing that he will do has the potential to do is to harm his daughter in the process. Because if he fights for ownership and doesn't relinquish it or turn it over to Madam Sharika, and she doesn't have a way to buy him out, then they're going to sell the house. and split the profits to go get new properties. And this happens all the time. So, I mean, he wouldn't be the first person to want what belongs to him. And I think, to be honest with you, if you have interest in property, I wouldn't walk away from it. So I wouldn't suggest that anyone else walks away from it. I think if you have ownership, then you should, maintain your ownership and your interest. But sometimes you have to weigh the two. Is it going to be beneficial for the child? Is the child going to have to be displaced? Will the child be able to be cared for? In the sense of, are they going to have their own room? Is in the sense that when you break up the family, husband and wife breaks up, and they take the marital home and they sell it. Well, you're only going to get your portion, which is half of the proceeds. That's typically a down payment into another home. Will Madam Shrika have the ability to pay for another home that will allow the child to have her own bedroom? Or will she have to, get a one bedroom? Or are they going to have to be in an apartment and not actually buy another home? Those things are what people weigh against when it comes down to going through a divorce. And so there are some families and some men who leave the marital home that will say, you know what, I don't want my child suffering over this divorce any more than they have to. So give them the home and then use the proceeds that would be my portion, use that as child support, as a payment as child support. So you can do that, but you have to go to court and work it out. They don't have a schedule. You know why they don't have a schedule? Because that's his home. He coming and going like he wants to come and go. They definitely need a divorce. And the judge expresses that because the divorce will help them to define the schedule of seeing the child, define what's going on with the community property, and put things in place that will help to eliminate some of the control that he's just experienced or, giving towards his ex-wife or his estranged wife. The other part of what I wanted to talk about, so we talked about having mail sent to your house, adverse possession. The other part of it is you cannot use a TPO to kick someone out. Now, playing devil's advocate, just because we want to look at this in the holistic way as we possibly can, there is a case that Judge Manning had, and hopefully it's somewhere in one of our videos. If not, then I'll look it up and see if I can find it. But there was a case that Judge Manning had, and the gentleman sought to evict the woman from his house. He purchased the house before their romantic involvement. They became romantically involved. She moved in with her child, and then they decided not to get together, to stay together. He moved out and gave her some time in the house on her own. Then he's, kept playing around with her, making her feel like they were gonna get back together, and then they didn't, and they were, and then they didn't. So she, she felt like he was playing with her emotions. But at the end of the day, he filed for an eviction so that she would move out of the house that rightfully was his house. He owned the house, it was his house, but he moved out to give her space for a while. And so Judge Middleton commends him for going through the court system to do it, because what may happen is they just take the clothes and drop it outside and kick you out on a physical note versus going through the eviction process. The problem that I have with that is when you're in a romantic relationship with someone and you use the process, the landlord-tenant law process to evict them, it goes on their record. So now it becomes difficult for them to have a new place in their name, because now they have a judgment of an eviction, which this eviction was based on romantic involvement. And, but at the same time, when he said get out, you should have just got out, right? So that would be a great time to have a stipulation to have a conditional dismissal, right? Like, let's dismiss this case if you're out within 10 days. if you're out within 5 days, then we'll just dismiss the case so that it's not on your record. But they too were in pro per, and no one argued that. And so I doubt that that's where it's going to end for them. And so in this scenario here, she's getting a temporary protective order. And I hope that she's getting a temporary protective order because it's necessary and not as a means of keeping him from the house that actually is his house. You know, I really do. So these are the elements that we were talking about relative to real estate today. Understanding what adverse possession means, knowing that for the state of California that it doesn't in fact exist, having possession of the property where the other person does not. So obviously that's not this case, but paying the taxes 5 years in a row, and some other steps will give you adverse possession of the property. So you want to make sure that if you have ownership of the property together, that you are not lacking on what you're supposed to be doing, and you're not allowing them to just do everything. Because sometimes you say, "Oh, you want to pay the taxes? Oh, good, you pay those taxes." Problem becomes 5 years down the road in California, they can say, "Well, this is my property because I'm the one paying the taxes. They don't come over. I'm always over." Da 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 da. Right? Adverse possession. The next thing is, wanted to definitely talk about not using the court system in a weaponizing way. Don't get a TPO on somebody unless you actually need it. Don't use it as a means, because sometimes some people do use the TPO trying to get the person evicted from the property or to keep them from being in the property so that they can in fact have the property to themselves without having to pay them any money or go through a whole new leasing process and qualifying on their own with their own credit, because maybe their credit won't sustain them. So that's another measurement. And the other thing is, if someone's getting mail at your house, they're establishing residency by doing so. Unless that's something you want them to do, please don't let them do that. Please do not let them do that, because then they will turn around and move in and talk about they have tenant rights and become squatters, you know. So unless you don't mind, you can truly trust them, let's not have that done. All right, that was a very weird way to get some real estate pieces and education out of there, but hopefully it was helpful and entertaining all the same. Stay legal, use professionals to do the professional job. If you want a professional job, get the professional. If you're trying to just have it look crazy and be crazy, and then fine, represent yourself, then do it for yourself. And accept all responsibility. When you fall on your face, don't cry about it. You did it to yourself, because he's doing it to himself right now. Because and with the he put holes in the property, right? Because he was punching the property, and he defends himself saying, "You know, I was frustrated. I was frustrated because I was locked in this room." And he tries to articulate that his frustration stemmed from the other gentleman waving a gun or showing a gun at him, right? And it's his house, and he just felt like real disrespected with that, right? And I think he doesn't want anyone else cutting his grass. And you may not understand this, but trust me, a man in his grass means big things. When you are a homeowner or the man of a household, and you're cutting the grass and you're watering the grass, it's a sense of pride, of ownership. It helps you to feel and reminded that you've made this accomplishment of home ownership. So there's a psychological thing behind that. So I understand why he's so fussy about, I don't want another man cutting my grass. That's my grass. I'll take care of my grass. Problem is, there he needs to go to a divorce, because maybe he only got half a grass. Like, how much grass he got over there. But that probably did set him off, because there is that emotional connection men have to cutting the grass and watering the grass in front of their house. It's their pride of ownership. They're taking care of it. It helps them to feel good. So some other man cutting their grass is a problem. I don't think they've had any particular sexual connection all this time. So I don't really think he cares about that's her man. I think he don't want her man touching his house. That's what I think. He don't want her man cutting his grass. He don't want her man in his house because that's disrespectful. Go get you a boom boom room. I done got my boom boom room across town, so you go get yours. Don't do that in the house. He can't control that. He can't. When they separate, when they divorce, you cannot control who is coming in and out of that person's domicile. The best you can do is request that the court deal something on a family basis to protect the child from being overly exposed to random people. But that's mostly a request that maybe the other person will abide by and may not. It's not really enforceable. Like you can't tell me who to be friends with, kind of thing, right? But you can say, I want to ensure that my child is protected from overactivity and don't give them any more confusion. So, be friends in a friendly place away from my child. You can say that, and I'll see how far you can get, because you can ask for anything, and unless you ask, you won't have expectation of receiving, because no one can foresee what your request will be. You have to actually ask it. But that I understood that he was taking that seriously. But what I did, if he had an attorney, he probably would have had better prep. Because what I didn't understand is why he didn't keep his representation up. This is why we know he's lying, right? Because he can't keep the lie straight. He said, I've never put my hands on her. I've never hit her. And then he goes and said, well, I punched the walls, but not in a violent way against her or anything. Versus saying, because I was so frustrated and I felt so threatened in my own house and disrespected, I punched the walls. This is the evidence, Your Honor, that I would never punch her. She was there, but I didn't touch her. I touched the walls. That's how I get my anger out. Maybe I hit the wall or I go to the gym or walk around a block, or I get the energy out in more healthier ways so that I'm not putting my hands on her. No, I shouldn't have hit the wall, but I figured that was a better thing for me to hit the wall than her, because I don't want to be violent against her and I want to be violent against this man who, whatever. But instead, he just said, because I was locked in a room. So what he does is he gives hyper, or what should I say? How should I put it? He just makes it worse, if you will. He makes it a bigger scenario when he turns around and says, I'm so angry and so frustrated that I have to hit something, so I hit the wall, right? Like, he makes it, I hit the wall, like, because I was frustrated because this man had a gun and I'm locked in the room. This is what he says. He claims he was locked in the room. So I think his thought was, because he doesn't articulate it too well, but it sounds like his thought was, I was keeping my loved ones away from him because he seemed to be unhinged and he had a weapon. And I, kept my girlfriend and the child in a safe place, and I stayed with them, and I was upset. So I was trying to get my anger out and ended up hitting the wall. I don't know about 3 different times, but to me, it sounds better than just saying, to me, it would be better for him to say, I don't want to hit any person, and I definitely didn't want to hit her, though. I was very upset that she had me and my child in harm, because she had him around someone who was dangerous. And so instead of getting into an altercation and instead of putting any hands on any other person, I took it out on an object that, can be repaired easily and, wouldn't hurt a person. So instead of him making those claims, he just says, I was so frustrated I hit the wall. I just thought it was bad to have it said that way. It probably would have ended up the same kind of result, but whatever, whatever. And when it comes down to the house, he owns half of it. So, if you have your own car and you start getting your anger out and you want to turn your car into one of those angry rooms and get a bat and just start whacking at your own car and beating it up, it's your car. You can destroy your own property. You have every right to destroy your own property. The issue becomes if someone else also takes ownership in it. When you're beating up on something, you're devaluing the property as a whole. You're affecting their interest. So that's a problem. So he can fix the wall. He would be responsible for fixing the wall so that when they do go to sell it, they get the maximum return when they go to claim their interests. All right, I gotta go. It's time to go. But anyway, I've had a great time with you. Thank you for hopping on with me. I hope you've enjoyed it. Go ahead and, put comments and let us know what you're thinking. Now, don't go out there trying to steal somebody's house through adverse possession. That's not right. That's not right. Just know the law so that you can abide by the law, okay? All right. Lyric Armstrong, your real estate agent and advocate. Don't forget, you got work. You got work to do. You have homework. Like, share, and subscribe before you leave. All right. Bye, everyone.